It's 8:15 a.m. I'm in downtown Houston in the courthouse, enjoying a beautiful view of East Downtown. That over there is the Maxwell House Coffee Roastery. It's closed now. That is the baseball stadium. That's the Buffalo Bayou. One block over is Allen's Landing. That's where Houston was founded by the Allen brother. The reason I'm here is for a hearing on a discovery matter, and I'm the respondent. I'm responding to the other side's motion to compel. I think I slept 4.5 hours this morning because I was getting ready for the hearing. I show up at 8 a.m., scheduled for the 8 a.m. hearing, and the lawyer for the other side didn't show. They backed out. They sent an email to the court notifying that they're passing on the hearing. So what this means in practicality is that lawyers or parties are allowed to file motions, at least in state court, and then if they choose not to fight it, they can pass on it, just notify the court and the other side. They happened to not tell me about it, and I showed up. But I don't mind showing up. I like it because I get FaceTime with the judge, and more importantly, the 10 or 15 minutes of FaceTime with the courtroom personnel, the bailiff, the court clerk, and the court reporter. It's good to get to know them because then you become an insider because of the repeated exposure. So I enjoy that benefit. The views are also great. I try to look on the bright side of everything. But for as far as this case goes, this is the third time the other side passed on their motion. And what this kind of tells the judge is that it implies that I, as the responding party, have been working with them, and they really don't believe in their motion. So when a lawyer passes on his or her motion, they run the risk of showing a lack of confidence, meaning they run the risk of showing that they really didn't mean it, and you're crying wolf too many times. The judge has implied, there's an implied meaning to the judge that says, is this party really serious about this motion? Because if it was so important, they should have just gone to a hearing, argued it, let the other side respond. But just dragging it along, the court clerk and court personnel, you can tell they're from their response that this is the third time it's happened. In this case, it tells them that, hey, maybe it's not a good faith motion, okay? So by just physically showing up, getting ready to battle this motion, I feel that my clients have won several things. It shows that they have a lawyer's willing to fight for them on this motion. They believe in it, and he's willing to show up. Showing up matters to argue on their behalf, and the other side didn't show up for the fight. And a no-show is still a no-show. And so it's a small win because next time, if they actually set this for a hearing and they show up and I show up, I think implied the judge will know that, all right, you guys you filed this motion like over a month ago and you keep moving it, 2 months ago, and you keep moving it. Is it really that urgent? Is it really that important to you? Because if it was, you would have gone to court the first time. So I count that as a win. Now I am going to go back to the office and work on my other cases, give my client a quick update on the result of today's lack of hearing. But it's kind of good because I got 3 minutes of FaceTime with our judge, and I can tell the client about that. And now it's time let's get back to work.